Good morning. Happy Friday. I have had innumerable requests to make a video on what happened with Earl's motion for a new trial. And to be perfectly honest with you, beyond what people like the Frog have reported, I don't know. The motion was denied. It was a motion. It was not an appeal. Anybody who tells you it was an appeal doesn't know what they're talking about because it was a motion. It was heard, if not by the judge who sat for the trial, then it was heard by a judge at the trial court level. It was not heard by a justice of the Court of Appeals. It was heard by a trial judge, probably the trial judge. But again, I don't know. Anybody who tells you that it was an appeal doesn't know what they're talking about. Anybody who tells you they knew what the outcome would be also doesn't know what they're talking about. The only thing we had was the moving paper, the actual motion itself. We didn't have any of the evidence that it referenced. We didn't have the transcript. We didn't have the affidavits. We didn't have anything like that. We did not see the opposition paperwork filed by the prosecution, if in fact there was any opposition paperwork filed by the prosecution. So the only person who would know which way the judge was going before the actual motion hearing would be the judge, because the judge would be the only one who would see each side's moving papers and the evidence that supported each side. So without having access to that, I really can't give you anything substantive beyond this. Assuming that the court found the evidence to be not supported or false, untrue, the judge did not weigh it in Earl's favor. Assuming that to be the case, the appeal that Earl has filed, he's filed a notice of appeal, I should say. He hasn't filed the actual appeal itself. He's just filed a notice of appeal at the trial court level, letting the trial court know that they would, in fact, be filing an appeal. They're appealing the denial of the motion for a new trial. This is now going to be the appeal for those of you who are following along at home. So there's one of two real ways for this to go. Either the judge determined at the trial court level, the judge determined that the evidence did not warrant a new trial, i.e. he did not place the same weight on the evidence that Earl wanted him to, or he decided that as a matter of law, the evidence did not warrant a new trial. So those are the two ways it's going to go. If it's a question of the weight of the evidence, then Earl's appeal is likely going to fail, because that's going to be under the abuse of discretion rubric. And the abuse of discretion rubric means that the appeals court is going to have to determine that no reasonable judge would have been able to come to that conclusion based on the evidence. You can see how that would be a very difficult task to prove by Earl. So if it's an evidence issue, if it's the credibility issue, if it's the weight of the evidence, anything evidence related, other than the admission of evidence or non-admission of evidence, then it's going to be very hard for Earl to win. If it is a question of law, whether or not legally, based on the evidence that the trial court found to be credible or weighty, if as a matter of law that entitled Earl to a new trial, well, that's going to be under the de novo standard, which means that the appeals court is going to take all the evidence, all the facts that the trial court found to be true or credible or weighty, and based on that, the appeals court is going to apply the law as the appeals court understands it. They're going to ignore whatever conclusions of law the lower court made, the trial court made. And so Earl is going to have a better chance of prevailing on an appeal based on a mistake of law. But again, we don't know. We don't know. I mean, there's so many. I don't even know if the trial court judge, the one who determined whether or not he would grant or deny the motion, I don't even know if he issued a statement of decision, i.e. if he put down in writing what facts he found to be true, what facts he found to not be true, what facts he gave weight to, what facts he did not give weight to, etc. What his legal basis for the ruling is. I don't know anything. And you don't know anything. And so anybody who's going to say that they know which way this is going to work out, they're probably lying to you. Now, there's a reason why attorneys can't guarantee results for their clients. There's a reason for that. It's because there's never any guarantees in law. So if attorneys can't tell you, I know the way this is going to come out, well, there you go. So that being said, does this somehow vindicate the people who were in there doing the things like the Dougies of the world, the crayon eaters, the people who are going in there and talking to the jurors, the people who are going in and making a scene in front of the jurors, the people who are turning the courtroom into a clown show? Does it somehow vindicate them? No, it does not. Because of their actions, they have given Earl ammunition, not just for the motion for a new trial, but for his appeal. And who knows how long it's going to take for the appeal to be heard. When the appeal is heard, there's really 4 ways it can go. Either it could be granted or denied summarily, i.e. without an opinion. Just a slip opinion says, the motion is granted, the motion is denied, without any real basis for it. Or it can be granted or denied with all the facts that the appeals court used, a statement of facts, a statement of the law, the analysis of it, and then the conclusion. I hope that we get the full shebang. Whatever it is, granted or denied, the full shebang with these are the facts, this is the law, this is the analysis of the facts of the law, and this is the conclusion that the appeals court comes to. Because it would be nice if we didn't have these questions. I have always, you can go back to the first videos I made about this, about Earl's arrest, about the charges against him. I have always maintained that the best case scenario is that Earl gets a full and fair trial, and that based solely on the merits of the prosecution, he is either convicted or acquitted. And it is unfortunate that it's been tainted. And I think one of the ways that I hope that we can eliminate some of the taint, either way, is if we get a full decision from the Court of Appeals. I don't know if we will, but I hope we get a full and hopefully published decision from the Court of Appeals. That would put to bed a lot of these bugaboos that are going around, because there are people who still maintain Earl's innocence. You have to understand that. Whether or not you do, some people do. And whether or not you do, some people disbelieve, or some people believe he did it, some people believe he didn't. And it would be nice if we had some closure, some real closure. So that's my hope. I'm not an Earl fan. I've never been an Earl fan. I've always believed he did it, but I'm not stupid enough to mistake my belief for knowledge. And if you are, well, I can tell you what the law is and how to apply it, but I can't understand it for you. Thanks for watching. Have a great day.